Michigan Real Estate Exam Mock Exam. Question 1. During a seller consultation in Traverse City, a team member encounters a rule involving providing written operating policies and procedures. Which response follows Michigan law, while the file concerns a new construction home, a buyer representation agreement, and a protected -class inquiry? Option A. It is optional if the firm has a logo. Option B. It may be delegated to a buyer. Option C. It is part of adequate salesperson supervision. Option D. It is prohibited as legal advice. The correct answer is option C. It is part of adequate salesperson supervision. Written policies give affiliated licensees consistent directions for regulated activity. For exam purposes, focus on the regulated relationship rather than an informal business custom. Branding or client instructions cannot replace internal operating guidance. Question 2. A branch manager is preparing for a listing presentation in Muskegon. Which statement correctly addresses a contract clause that removes the broker's authority to supervise a salesperson, while the file concerns a mixed-use building, a commission disbursement form, and a disputed repair credit? Option A. The clause is required for contractors. Option B. The clause transfers supervision to the seller. Option C. The clause is valid if notarized. Option D. The clause is not permitted. The correct answer is option D. The clause is not permitted. Employment wording cannot strip the broker of statutory supervisory power. The transaction context changes the facts, but it does not change the underlying licensing duty. Notarization does not validate a provision that conflicts with licensing law. Question 3. Which Michigan requirement should control when a licensee deals with an additional Michigan place of business maintained by a broker during a buyer consultation, while the file concerns a cooperative unit, a draft purchase agreement, and an electronic signature? Option A. A branch office license is required. Option B. The location is automatically covered forever. Option C. The salesperson obtains a separate broker license. Option D. Only an MLS subscription is required. The correct answer is option A. A branch office license is required. Each additional brokerage location must be connected to an authorized branch office. A written office procedure should produce the same result in comparable transactions. A membership account or salesperson credential does not license the location. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At an offer review, the brokerage discusses a branch office located more than 25 miles from the nearest boundary of the main office municipality. Which conclusion is most accurate, while the file concerns a farm parcel, a branch-office inspection report, and a referral arrangement? Option A. The branch must close permanently. Option B. A customer may supervise the branch. Option C. No supervision is required. Option D. An associate broker must provide direct supervision at the branch. The correct answer is option D. An associate broker must provide direct supervision at the branch. Distance from the main office municipality triggers an enhanced branch supervision requirement. In the described setting, the brokerage should document the step and apply it before moving forward. Remote availability alone does not satisfy the stated arrangement. Question 5. A compliance question in Battle Creek concerns the physical location requirement for an individual broker, broker company, or branch office. Which action or statement is appropriate, while the file concerns a lakefront cottage, a buyer representation agreement, and a team social media post? Option A. Use only a post office box anywhere. Option B. Maintain a physical address in Michigan. Option C. Use the address of any salesperson. Option D. Operate without a listed location. The correct answer is option B. Maintain a physical address in Michigan. Brokerage offices must have an identifiable Michigan business location. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. An unrelated person's address cannot stand in for the licensed office. Question 6. How should a Michigan employing broker handle a situation involving mixing client transaction money with brokerage operating funds, while the file concerns a townhouse, a commission disbursement form, and a record inspection request? Option A. A commingling that can lead to discipline. Option B. A permissible commission advance. Option C. A standard marketing practice. Option D. Required interest allocation. The correct answer is option A. commingling that can lead to discipline. Money belonging to others must be accounted for separately from the firm's own operating cash. For exam purposes, focus on the regulated relationship rather than an informal business custom. A business convenience does not justify blending the accounts. Question 7. Which choice best applies the state rule concerning using money belonging to a client for the broker's own purpose to a license application, while the file concerns a urban infill property, a draft purchase agreement, and a branch-office distance issue? Option A. A lawful prioration. Option B. Conversion of entrusted funds. Option C. A disclosure waiver. Option D. A comparative market analysis. The correct answer is option B. Conversion of entrusted funds. Personal use of entrusted transaction money is a serious breach of accounting duties. The transaction context changes the facts, but it does not change the underlying licensing duty. Closing calculations and valuation work are unrelated concepts. Question 8. A file from Kalamazoo raises an issue about the handling terms for property management money. Which answer identifies the governing requirement, while the file concerns a subdivision lot, a branch-office inspection report, and a financing contingency? Option A. Let each tenant choose after payment. Option B. Place them in the deed only. Option C. State them in the written property management employment contract. Option D. Leave them to an oral understanding. The correct answer is option C. State them in the written property management employment contract. The management agreement must address safekeeping, disbursement, use, and account treatment. A written office procedure should produce the same result in comparable transactions. A deed or tenant preference does not establish the manager's financial duties. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing a property management meeting, which rule should the property manager apply to records requested by an authorized department representative during normal business hours, while the file concerns a rural acreage, a buyer representation agreement, and an unrepresented consumer? Option A. Require a court judgment in every case. Option B. Allow inspection of reasonably necessary documents and records. Option C. Provide only advertising photographs. Option D. Destroy the records immediately. The correct answer is option B. Allow inspection of reasonably necessary documents and records. The department may examine business records reasonably connected to an investigation or regulatory review. In the described setting, the brokerage should document the step and apply it before moving forward. The inspection authority is broader than a request for promotional materials alone. Question 10. A Michigan exam candidate reviews a scenario involving a licensee selling property in which the licensee has an ownership interest. Which option reflects the current licensing framework, while the file concerns a single-family residence, a commission disbursement form, and a confidential price limit? Option A. Disclose only after closing. Option B. Disclose the ownership interest and licensure in writing before an offer is signed. Option C. Tell only the lender orally. Option D. Conceal the interest if the price is fair. The correct answer is option B. Disclose the ownership interest and licensure in writing before an offer is signed. A buyer must receive advance written notice when the seller is also a real estate licensee with an interest in the property. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Fair pricing does not excuse non-disclosure. Question 11. The broker's policy manual addresses the purpose of a seller property condition disclosure. Which provision should it contain, while the file concerns a small apartment building, a draft purchase agreement, and a change of employing broker? Option A. Guarantee the property will never need repairs. Option B. A transfer title to the buyer. Option C. Provide the buyer with required information about known property conditions. Option D. Replace the buyer's inspection. The correct answer is option C. Provide the buyer with required information about known property conditions. A statutory condition statement communicates the seller's knowledge about covered aspects of the property. For exam purposes, focus on the regulated relationship rather than an informal business custom. The document neither substitutes for due diligence nor conveys ownership. Question 12. A regulator asks about a known material defect that affects a purchaser's decision during a brokerage review. Which response demonstrates compliance, while the file concerns a office condominium, a branch-office inspection report, and an owner-licensee conflict? Option A. Communicate the material information as required rather than conceal it. Option B. Hide it until after possession. Option C. Describe it as confidential pricing data. Option D. Remove it from every transaction file. The correct answer is option A. Communicate the material information as required rather than conceal it. Material property information can affect value, safety, or a reasonable buyer's decision. The transaction context changes the facts, but it does not change the underlying licensing duty. Deleting the fact from a file does not remove the underlying duty. Question 13. Which statement would be safest for a licensee to follow when a seller disclosure form compared with a professional inspection becomes relevant, while the file concerns a condominium unit, a buyer representation agreement, and an expired license issue? Option A. The form guarantees structural soundness. Option B. The form makes all contingencies void. Option C. The disclosure does not replace an independent inspection. Option D. The form is an appraisal. The correct answer is option C. The disclosure does not replace an independent inspection. The seller statement reports knowledge rather than providing a complete technical evaluation. A written office procedure should produce the same result in comparable transactions. Appraisal and contingency rights serve different purposes. Question 14. A dispute arises during a compliance interview over refusing housing-related service because of a protected characteristic. Which principle resolves the issue, while the file concerns a retail suite, a commission disbursement form, and a property-management payment? Option A. Permitted client screening. Option B. A lawful appraisal adjustment. Option C. Unlawful discrimination. Option D. A required agency disclosure. The correct answer is option C. Unlawful discrimination. Housing opportunities must not be restricted on a prohibited discriminatory basis. In the described setting, the brokerage should document the step and apply it before moving forward. Agency paperwork or valuation methods do not justify unequal treatment. Question 15. In Flint, an associate broker must decide how to proceed with directing buyers toward or away from neighborhoods based on protected characteristics. Which decision is consistent with Michigan requirements, while the file concerns a manufactured home site, a draft purchase agreement, and a delayed possession term? Option A. A title search. Option B. A lawful zoning variance. Option C. A neutral market analysis. Option D. Steering and discriminatory practice. The correct answer is option D. Steering and discriminatory practice. Neighborhood recommendations cannot be based on the protected composition of residents. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Title and zoning work do not authorize discriminatory channeling. Question 16. Which exam answer accurately classifies the rule involving advertising that indicates a preference or limitation based on a protected status, while the file concerns a 2-unit rental, a branch-office inspection report, and a cooperating brokerage? Option A. A required broker identifier. Option B. Permitted puffery. Option C. A lawful deed restriction. Option D. A discriminatory advertising. The correct answer is option D. Discriminatory advertising. Marketing language may not signal that protected people are unwelcome or preferred. For exam purposes, focus on the regulated relationship rather than an informal business custom. Broker identification and ordinary promotional opinion are separate issues. Question 17. A new policy is being drafted for reasonable accommodation for a person with a disability. Which language belongs in the policy, while the file concerns a historic residence, a buyer representation agreement, and a rejected counteroffer? Option A. Consider a necessary change to rules or practices unless an applicable defense exists. Option B. Treat the request as a commission dispute. Option C. Require the person to waive civil rights. Option D. Reject every request automatically. The correct answer is option A. Consider a necessary change to rules or practices unless an applicable defense exists. Disability protections may require flexibility in policies so a person can use and enjoy housing. The transaction context changes the facts, but it does not change the underlying licensing duty. A brokerage-fee issue does not resolve an accommodation request. Question 18. During team training, the supervising broker tests knowledge of fraud, deceit, or dishonesty in licensed practice. Which answer should the team select, while the file concerns a student rental, a commission disbursement form, and an assumed business name? Option A. A required form of negotiation. Option B. A grounds for occupational discipline. Option C. An automatic contract amendment. Option D. A protected marketing strategy. The correct answer is option B. Grounds for occupational discipline. Dishonest conduct undermines the competence and trust expected of a licensee. A written office procedure should produce the same result in comparable transactions. Negotiation does not authorize intentional deception. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain gross negligence or demonstrated incompetence. Which explanation reflects Michigan law, while the file concerns a vacant commercial parcel, a draft purchase agreement, and a security minus deposit question? Option A. A protected advertising style. Option B. An exemption from supervision. Option C. A substitute for continuing education. Option D. Conduct that can support disciplinary penalties. The correct answer is option D. Conduct that can support disciplinary penalties. Serious carelessness and inability to perform regulated work can trigger professional sanctions. In the described setting, the brokerage should document the step and apply it before moving forward. Education and advertising rules do not convert incompetence into lawful practice. Question 20. Which compliance step is required when the transaction facts involve false advertising by a licensee, while the file concerns an industrial site, a branch minus office inspection report, and a dual minus representation concern? Option A. A method of deed delivery. Option B. A permitted team slogan in every case. Option C. A title minus insurance requirement. Option D. A disciplinary violation. The correct answer is option D. A disciplinary violation. Real estate marketing must be truthful and comply with brokerage minus identification rules. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Deed and title procedures are unrelated to advertising honesty. Question 21. A team member notices a potential problem involving helping another person perform regulated brokerage work without a license. Which response should occur first? While the file concerns a new construction home, a buyer representation agreement, and a protected minus class inquiry. Option A. A required referral method. Option B. Evading unlicensed practice. Option C. Lawful delegation to any friend. Option D. A zoning enforcement function. The correct answer is option B. Aiding unlicensed practice. A licensee may not enable an unlicensed person to perform activities reserved for licensed practitioners. For exam purposes, focus on the regulated relationship rather than an informal business custom. Calling the activity a referral does not change its substance. Question 22. The state portion of the exam presents facts about practicing while a license is suspended, revoked, or lapsed. Which result is supported, while the file concerns a mixed minus use building, a commission disbursement form, and a disputed repair credit? Option A. The employer may privately reactivate it. Option B. Only advertising is prohibited. Option C. The person is treated as unlicensed. Option D. The license remains active for pending deals. The correct answer is option C. The person is treated as unlicensed. Authority to practice depends on a current license in good standing. The transaction context changes the facts, but it does not change the underlying licensing duty. Only the department can restore lawful status through the applicable process. Question 23. Which brokerage practice properly addresses failure to comply with a final board or department order in the Kalamazoo transaction, while the file concerns a cooperative unit, a draft purchase agreement, and an electronic signature? Option A. A separate basis for discipline. Option B. An automatic license renewal. Option C. A private contract defense. Option D. A fair minus housing exemption. The correct answer is option A. A separate basis for discipline. Final regulatory orders are enforceable obligations of the licensee. A written office procedure should produce the same result in comparable transactions. Private transaction terms cannot override the order. Question 24. A licensee is comparing 4 procedures related to keeping a client's confidential negotiating information private. Which procedure is lawful, while the file concerns a farm parcel, a branch minus office inspection report, and a referral arrangement? Option A. A fiduciary responsibility subject to legal disclosure exceptions. Option B. A reason to hide known hazards. Option C. A duty owed only to competitors. Option D. An optional courtesy after closing. The correct answer is option A. A fiduciary responsibility subject to legal disclosure exceptions. Agency loyalty includes protecting confidential information obtained through representation. In the described setting, the brokerage should document the step and apply it before moving forward. It cannot be used to conceal material facts that must be communicated. Question 25. At the end of an advertising campaign, the parties question presenting offers and material transaction information promptly. Which statement provides the best guidance, while the file concerns a lakefront cottage, a buyer representation agreement, and a team social minus media post? Option A. A prohibited communication. Option B. A task reserved for the assessor. Option C. Optional when commission is small. Option D. Part of competent and loyal client service. The correct answer is option D. Part of competent and loyal client service. Clients need timely information to make informed decisions about offers and risks. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. The size of compensation does not reduce professional responsibility.